I'm Drake Menning, and this is my chapter video summary number 2. These are the key points I learned in chapter 2. The legal environment of business is not just one simple definition, but includes several components. It is a study of legal reasoning, critical thinking and ethics, as well as the legal process of the legal system. It is also the study of the administrative process, along with areas of public and private law and international law. The study of the legal environment of business is characterized by critical thinking skills, legal literacy, understanding that the law is constantly changing, dealing with real-world problems, and the interweaving of many disciplines. There are 10 main reasons to study the legal environment of business, which are to become more aware of the rules for doing business, to familiarize yourself with the legal limits on business freedom, to be alert for any potential misconduct of competitors, to appreciate the limits of entrepreneurship, to be able to communicate with a lawyer, to become a more informed citizen, to develop employment-related skills, to explore the complexity of business decisions, to have a better awareness of business ethics, and to open your eyes to the excitement of law and business. I learned that jurisprudence is law in its most generalized form. There is great diversity in the meaning that the term law has. There are 7 accepted schools of jurisprudence or legal thought. They are natural law school, positivist school, sociological school, American realist school, critical legal studies school, feminist school, and law and economics school. Each of these have different characteristics with a different source of law. Another key point talked about are the sources of law. There are 3 direct sources of law, one being the legislative branch, which creates the laws, the judicial branch, which interprets the laws, and the executive branch, which enforces the laws. There is also an indirect source of law, being administrative agencies, which are federal regulatory agencies. There are many steps involved for a bill to become a law and many committees that it must pass through. There are different levels of government, including federal, state, and local, and each deal with different levels of the law. There are many classifications of law that are necessary to fully understand the legal environment of business. There is statutory law, which is made up by the legislative branch, and case law, which results from the judicial interpretation of the constitutions and statutes. There is also criminal law that is composed of federal and state statutes prohibiting a wide range of wrongful conduct. Civil law is for a litigation between private parties. Public law deals with the relationship of government and individual citizens, and private law deals with the enforcement of private duties. Other classifications of law are substantive law, which regulates legal rights, procedural law, which enforces substantive rights in court, and cyber law, which deals with laws for online communication. Another key point is the global dimension of the legal environment of business. With many American jobs being outsourced to other countries, trade treaties will make international dimensions of business important to U.S. companies and have an important impact on their decision-making in many aspects. The first key point I learned about in Chapter 3 is jurisdiction. This is the power of a court to hear a case and make a binding decision. There are different types of jurisdiction that the court must have to hear a case. The original jurisdiction is the trial court, which has the power to first hear and decide the case. A court with appellate jurisdiction can review a case from the trial court. Jurisdiction over a person is called personam jurisdiction. In rem jurisdiction is the power of a court to make a decision that affects property directly rather than the owner of the property. Subject matter jurisdiction is the power of the court to make a decision in a particular type of case. State court jurisdiction applies to cases that may only be heard in the state court system. Very few cases fall within the federal court jurisdiction, and most are within the state court jurisdiction. There are a few types of cases that can only be heard in exclusive federal jurisdiction, such as bankruptcy, criminal prosecutions, and government claims. There are also other cases that may be heard in the state or federal court, and these fall within the federal court's concurrent jurisdiction. The venue is where a case is brought, or the actual geographic location of the court where the hearing is held. This is based on where the defendant lives or the location of any property or incident in dispute. Within a court system, there is a federal court system and a state court system. Another topic talked about is the actors in the legal system. Within the legal system, there are different persons involved with different relationships to the business community. Attorneys are the legal representatives of the parties before the court. These attorneys have a law degree and pass the state bar exam and have high moral character. They represent the client in the litigation and negotiate for them. Attorney-client privilege encourages client honesty. The attorney cannot reveal any information given by the client without their permission. There is also a work product doctrine which says the documents prepared by the attorney for the client's case cannot be revealed without their permission. The judge is another important part of the legal system, and there are different kinds of judges. The trial court judge presides over a trial, while appellate judges serve on panels and review lower court cases. A judge also has the power to determine whether a law passed by the legislative violates the Constitution. This is called judicial review. The jury is another part of the legal system. There are randomly selected citizens to determine the questions of fact at a trial. A petit jury is for a trial court. There are usually 12 citizens on this jury to decide the facts in a criminal case and pronounce the defendant guilty or not guilty. A grand jury is a group of 12 to 23 citizens who are privately convened to decide whether enough evidence exists to try a defendant for a felony. In an adversarial system, a judge hears evidence and arguments from both sides of the case, and then the judge makes a decision based on the facts and the law as the arguments are presented. There are many steps in a civil litigation or lawsuit. There is the pre-trial stage, where informal negotiations may take place. If this does not solve the problem, they will initiate legal action. In discovery, the attorneys will gather information from each party and from witnesses. Jury selection will take place for the trial. There will be opening statements to explain the facts, and the plaintiff and defendant's attorneys will each present their case and cross-examine any witnesses before giving closing statements. The jury then deliberates, where they reach a decision and their verdict is read to the court. A class action suit is one where a large group of individuals joins as plaintiffs for a common complaint against the defendant. Global dimensions is the last key point. As trade among nations increases, America will become more involved in disputes with foreign nations. When an international agreement is made, countries can negotiate on which nation's court system to hear the dispute under. Since the U.S. has a different litigation system than most other countries, it is important to compare the system of each country before choosing. When thinking about how this would impact my approach to my job as an accountant, I feel I would just be more conscientious in my work and have a good standard of business ethics. If I do honest work and follow patient-client privilege, I would hope I will have no real legal issues. If I had a breach of contract or any other legal issue with a client or other business, I am now more aware of the legal system in business.